Illuminati, Islam, Salah, Attep, all our people out there. Once again, it's another video. We got the Minister of Law for Indigenous Services, Keng El Bey here. Once again, it's me, Chief Noble Bandela Elamine. Today, we will be discussing law, and we will be discussing the appellate process and how to appeal, and also how to prepare for an appeal. So with that, I'll let you go ahead and have the floor.
Alright, peace, brothers and sisters. Listen up close. I'm going to give you some intel on how you need to go about perfecting the appeal process. A lot of people don't know how to be specific when dealing with this transfer of jurisdiction, because you remember you're going from trial court to the appealing court. So you cannot bombard jurisdiction and just jump from one jurisdiction to another without certain things being perfected. So the first step, when you finish with your trial, you got to remember that whatever you argue at trial is that which you're limited to. You're limited to that argument. So you cannot go outside of that. That's a due process or a jurisdictional component, because you have to stay within the frame of what you discussed with the court. What was the issues that need to be resolved, or what was the issues that you and the other party addressed to the court to get resolved. Now, once you can perfect the process, the first step you have to do is you have to file a notice of appeal. When filing a notice of appeal, you have to file that within the timeline. So you got to remember, you got to look at not just once you go from trial, you're trying to make sure you perfect the process for appeal. You got to now start looking at the appealing rules and the local rules of that appealing court. So now the jurisdiction that you're looking at is the appealing rules and those local rules of the appealing court, and you got to make sure you perfect that process. So file a notice of appeal, and now in most states they have a civil docket sheet. I can't speak about how they do it around the country, but you might have file a civil docket sheet, and then you address the issues and you complete that civil docket sheet in regards to the issues and whatever, as far as the record, how you're going about, how the appealing court is going to obtain a record. Now you got to remember, the appealing court is a court of record only. They will not hash out any issues that was unresolved in the trial court. They're only going to deal with issues that were unresolved in the trial court only. They're a court of record. So when dealing with courts of records, they only deal with the records in front of them. If they don't have the record, then you can't argue it. You don't have the right to argue that, because it's outside of the scope. They can't take on new issues. They're not allowed to. They only here to deal with those particular matters that was ironed out. I just want people to understand that, because a lot of people get into the appealing process and then they start dealing with issues that never took place in the trial court, or they're trying to bring up due process issues that wasn't a part of the trial court. You got to stay on topic now. You got to make sure that you're focused on what you did in trial. So the first thing a lot of people don't understand, when you're dealing with the trial court, you have to learn how to safeguard your rights so that they can be transferred from the trial court to the appeal court, so that the appeal court you can say, hey, this is what the trial court didn't do. They didn't safeguard my rights. I have requested certain things within the jurisdiction by whatever rule, by the statute, if it's a statute, if it's a rule according to the civil rules or criminal rules, or if it's a local rule or rule of evidence. You have a lot of different rules. I even try to tell people, learn all the different forms of rules according to that state. So you, even the superintendent rules, so you can understand the functionality of each court and how they're supposed to operate and what is their specific design. So if you don't know these things, you have to make sure that you enlighten yourself enough to be able to navigate through this process, because it can get complicated. And then it can spin out of control, and then once you get closed out of jurisdiction, it's hard to get back in. So I'm trying to elaborate on certain points so everyone will understand how to deal with this. I can't elaborate on all the different rules in each application, because when we're talking about law, we're really talking about applications. Even when you're talking about statutes, it's an application, because when we're looking at the law, you got to remember the facts activate the law, not the vice versa. The facts activate the law. So that application, according to whatever the facts was, is stimulated by those facts. And if those facts don't equate to that application, it might dim down to a lesser included. And that's how the process works. You got to understand applications. We can get into that on another topic, but I talk about it as applications, and it's like a lock and key process. You got to make sure that you've got the right key going into the right lock, because once you don't do that and you try to jump jurisdiction, or you do stuff that's required, that's not, you try to do things before finishing the previous that is a requirement, you're going to be locked out of jurisdiction. They're going to dismiss it, or they're going to say you have to do this before you can do that. And you have to make sure that you understand these steps. Now, once you get to civil docket sheet, a lot of people then, the process now, you might have other issues that may be going back and forth between the parties. Now you got to make sure you look at these local rules and these appellate rules. But the local rules, you got to understand, the local rules is jurisdiction only for that particular court. Each court has their own set of rules designed for their functions. And certain courts have certain abilities that certain courts don't have. They might have some type of technological advancement that one court may not have. So they might have a little more perks. But you have to understand those local rules in order to make sure, to ensure that you're following that process to perfect it, or do it in the best manner possible, in which is feasible to work within the boundaries of that application of that court. So you got to remember that the local rules are jurisdictions specifically designed for that particular court. And with the appealing court, they have their own local rules. Now, you can still, now you might have a broader general rule that's for the entire state, or for that entire court. That covers more of a general jurisdiction that covers all the appealing courts. So even with filing the correct motion on a general application, you still have to follow the local rules. The local rule might have a specific way that they want you to do that specific state rule with that particular court. They may request certain things to be done, and you have to follow them to the letter. It may, like I said, it's probably different from around all states. So you got to ensure that you follow these rules to the letter to make sure you try to perfect this process. Because if you don't, you're going to find yourself going back and forth, and you might get your motions dismissed and your case dismissed on a technicality, and now you're trying to fight your way back in, which is difficult. So, and then there's a lot of complications also. There might be an unresolved issue that never been performed in the appellate court, that that may need to be set a new precedent on how to do something based upon some information, based upon something, a circumstance that had happened that need to be resolved in order to perfect that process. And it could be, instead of it being a plain error, it could just be an error that's unfamiliar to the court, that they haven't recognized before. So now you might have to even look at some case law and see if that ever happened under that application, or it may not be even an application that even exists to even deal with that subject matter. So you have to be very specific. Now moving on. You have to understand, once you complete certain steps, now it might request for your briefing. Now, like I said, every court might require certain things different. They might require that you file it electronically. It might be something that you have to do or process. I don't know. But you have to follow that process according to the local rule and the state rule to perfect it. So they go hand in hand. So if you do something correct on the state rule and don't perfect it or do it correct on the local rule, it could get rejected because, once again, you didn't follow all the rules. So your brief, a lot of people don't understand how to do briefing, or they don't know how. So a lot of that stuff is not in the rules. Sometimes they might not even have an example onto how to do a briefing. So
what is a brief? What is a brief?
A merit brief is basically, it has several layers. It's going to have your issues, it's going to points of law, it's going to have what I call points of facts that you may have argued that may be reflected in a record. They might have a table of contents. It's going to have those various arguments, and you have to label it all correctly. In each court, I don't want to get into detail to tell you how to do something, because each court may require something different. So every court may not be exact. A particular court might they might call it something different. So I don't want to tell you how to perfect the process on a brief.
A general understanding of it. You know, is there a general?
Yeah, a general understanding.
Every court would probably have this basic standard.
There's a standard. The standard is that you're going to probably have your table of content, your law, your points of law, points of authority, your citations, and your argument. Those are the basic components in which you're going to have your briefing be made up of your briefing. There's other stuff that you may have that may be required by the court that you might have to do, but I can't get into that because we're talking about all these different state courts, or even federal courts that may be different. Most of the time, what I have realized that the federal court is more consistent versus than the state courts, but I mean, that's just how it goes. But the thing that I want people to understand when dealing with these briefings, you have to meet the deadlines required by everything. Every rule have a specific time frame. So you got to look at that. The local rule might require you to do something, and the state rule might require you to do something. You got to make sure you're in compliance with the rule, so that you can ensure the integrity of the process, so that they can get your filings, and then they can entertain jurisdiction on the subject matter to make a decision on your motion. So, and then finalizing your brief, making your argument. So every court do it different, and sometimes they allow you. You can request. Some courts require that you have. Some courts require there be an oral argument. In some cases, it's not necessary to have a oral argument. So, some courts give you a choice. But like I said, Each court is different. You got to make sure you read those appellate rules and those local rules. And you got to read, I tell people, read your rules of evidence. Read your superintendent rules. Go over all these different rules and understand certain things. And we're talking about jurisdiction, so each rule has assigned, like if it's a state rule, then it covers the ground of the whole state. So any court within that state, you can bring that into fruition, or not fruition, but you can bring that application into the court and use. So the thing that I want to express is, even sometimes, like, you have to understand that some courts, like some things, like even a statute, it's not applicable to certain smaller courts, because a smaller court may have a specific ordinance or code that is not general throughout the state. They might have a waterworks that may need a specific function or whatever that is specific to that community. It may be a small community, a village, and they might have even a noise ordinance that they might even have within that village or community. So the state may not have an application or a statute that deals with that issue. So you got to remember, everything is not applicable under the state. So, but it could affect a constitutional right, but you have to know how to tie all this stuff in. So you got to remember, though, the state is not even required to even deal with constitutional matters, because the constitutional matters of the federal constitution is different from the state constitution. The state has their own constitution. Now, it could affect your constitutional right under federal constitution, but then that means you might have to go to the federal court and say the state is violating my right under their law.
So you say there's two different types of appeals. You start with state and then
the federal court.
The federal. Okay.
Right. The state and the feds have everybody have their own constitution. So, but it can affect your constitutional right on the state level and then on the federal level also. So that's what people need to understand. So it's not necessarily that you use United States Constitution, because remember, it's called the United States Constitution, and it has federal jurisdiction. Now, if the state courts entertain that, a lot of times they will entertain the Constitution, but I didn't see where a lot of times they won't. Sometimes they won't even entertain that, and then that may be something that you can bring up under federal appeal. But I don't think it's required for the state to always entertain constitutional grounds unless it's a state constitutional issue. And a lot of times, even when reading your state constitution, they would let you know that this is equatable to the federal constitution. They might say section 1 through 4 is equatable to this part of the Constitution of the federal or United States Constitution. So you got to really do your homework. You really got to understand. You got to really look into everything, and it can get very complex. It's once you understand the process, and that's what I try to tell people. You got to understand this process, because there's so many elements that exist within this process. And a lot of people forget about those. That goes out the window, and they only deal with the legality of it. So they go in there talking law. And a lot of times they don't really understand certain things. So they end up losing the case just on probably mere technicality. Most people lose their case on technicality. not argument, not pure argument. Lawyers most of the time lose on technicalities, not pure argument. Because some things is always, law is an evolving issue. There's always things that's evolving about law. If you've seen that now they're gay marriage, that's something that the courts has adopted. You know what I'm saying? So even in some states say, no, we're not going. Even though the United States have adopted that policy, we may not want to adopt that policy. Do they have the right though? Because you got to remember, state is separated, supposed to be separated.
It's separate jurisdiction, but it has its own power. Right?
Yeah, right. It has its own power, but they even separate. The state is a sovereignty.
Right, it's sovereign.
So the state has a right to do and dictate certain things, and do the federal government have the right to take that away from them?
Marijuana law is one.
Yeah.
Marijuana law.
Yeah. So you gotta remember, like, that's how the marijuana law, like, it's illegal on the federal, but in the state, it's legal.
Right.
So that means as long as you're in the confines of that state, it's legal. They can't come in, the federal government can't charge you with this, because there will be a conflict. And that conflict will be a certified conflict. So then you can argue that, like, no, the state gave me this remedy, so I'm allowed to use this. Now, why are y'all trying to take away this remedy? Now, the feds might say, okay, state, we're going to let you have that remedy, but we're going to put laws in place for your state to exercise those remedies.
Right.
So what they call are prerequisites. And this is what people need to understand. There are things, a lot of things about the jurisdiction, in order to move from one jurisdiction to another, even within the same confinement of that particular jurisdiction, there are prerequisites, like filing objections. Like, that is a prerequisite in order to get your stuff heard by a judge. If you fail to do certain things required by that rule, then you didn't meet the prerequisite or the requisite required to entertain jurisdiction, to sustain jurisdiction. So your case will automatically be dismissed, and they will adopt the magistrate decision. Now, the same process goes with filing an appeal. If you don't do certain prerequisites prior to transfer of jurisdiction, then they will dismiss it on the basis of you failing to perform certain tasks, and now jurisdiction is closed, you're off limits. Now you got to try to get the court to reopen, and you got to do certain things, and if you really don't know what you're doing, you're really going to have a hard time. So I advise people, when dealing with the appellate court, that you find people who are very familiar with this. And my saying is this, they say knowing is half the battle. So a lot of us attend to lawyers, because you got to remember, this is the legal system is a corporation. We're talking about corporations. So before, our first rule of thumb in all businesses, it has to be a business before it can be anything else. It has to make money, because if it don't make money, how it's going to sustain? It has to thrive. So when you're talking about corporations, we're talking about business affairs. So you got to understand certain business principles and concepts when dealing with these courts, so that you can understand how to deal with them and try to level the playing field to ensure yourself an effective pleading. See, we're talking about pleadings. So when you're dealing with these courts from appealing phase, from the trial phase to appealing phase, you got to make sure you perfect certain processes so that you can keep and sustain jurisdiction and have your pleadings heard, your arguments heard, and so that at least you have a fair chance of being effective in the courtroom. Now,
that takes me to a question. Post-trial motions, and how how important they are to the appeal process.
Oh, they're very important. See, along with post-trial, see, this is what a lot of people don't understand. When you going to the appellate court, you got to remember they're a court of record. If there is no record, or if you didn't hash out that issue before going to them, you cannot entertain that subject matter. It's lost. Now you confine to what you argue in the boundaries of the courtroom. It's over. Post-trial motions are very important. It allows you to hash out issues that was unresolved. It allows certain things. Each phase, you have your pre-trial, you have your trial phase. It depends on if civil or criminal, because you got your pre-indictment, your indictment phase, then you got your pre-trial phase, trial phase, and post-trial. And each section has a particular time that you can do within the boundaries of each jurisdiction. See, people don't understand. Those are jurisdictions also, because those are windows of time that you have to perfect certain things. And because once it goes on to the next phase, you are locked out of that previous phase. You can't go back. You're locked out. So you got to complete or toll the process to ensure whatever issues that need to be hashed during that time can be hashed out before you move on to the next phase, so that you can ensure the integrity and the fairness of the process, so that you will have everything created on record. So if you do go to appeal in court, you say, well, I exercise all my due diligence to ensure that when I get in front of there, I can argue everything that I needed to argue in the process. So now the appellate court has all the records, and it will reflect everything according to each process in which you may have argued and which the court may have denied you a right to do.
So what are some post-trial motions that
see, every state kind of does it a little different. I don't want to emphasize like particular post-trial motions because I want people to go and read for themselves what they need to do and how they remedy certain processes, because states word them a little different.
Okay.
Like, and it'll change. And if I tell them that they do this, somebody can file a motion of that caliber, or a motion distinctively on what I'm telling them, and it may be called something different within another state.
Okay.
So I want to make sure that people understand they have to look the importance of reading. You have to read.
Right.
Or get somebody who is qualified to help you understand what you need to do. That's why we're trying to develop something called a pro se advocate center. We can't tell you, give you legal advice, but we can tell you from our own experiences how to deal with that, how to deal with certain things. It's coming from our experience only. It's not an opinion. It's just our experience, and we can talk about our experience and how we dealt with the court on those issues. So, that's very important to team up with somebody. Even when dealing with a lawyer, you should be able to get somebody who's been familiarized themselves with the system, so they can even tell you what to do from your lawyer, show you how to deal with your lawyer, because some lawyers, they in it for the dollar, and they're just in it. I tell people justice is paid for. If you don't, the less money you got, the less justice you get. That's just the way it is. Yeah. It's big business. So if you ain't got nothing, you're gonna get very little. So people who's economically challenged, you really need to emphasize. We need to really get into this. This need to really be taught in schools, so that we can start safeguarding certain things, so that we, as people of melanated skin, coming from all types of parts of the world, cannot get alienated and find ourselves in the system unjustly, and we don't know how to remedy the situation.
Right. I got one more. Talk about the interlocutory appeal and how that plays into the appealing court.
Well, every process is different. The interlocutory appeal is different from the standard appeal. Most of the time, you're talking about when the court deny you a substantive right that challenge.
What's a substantive right?
Well, substantive and procedural is something like this. I'm going to emphasize on procedural so you'll know the difference between substantive. Procedural due process deal with the rules or the application itself. And it's set out, it's set in stone, it's pretty much obvious. It's in a rule, and it dictates how a certain process should be performed. And if they don't give you that, that would be a procedural due process.
What's an example of
Like
that?
for example, I'll say you file a motion to dismiss, and you file it within the timelines of it being dismissed, and the court never entertained your motion. Then they would then violate a due process, procedural due process, because you conform to the rule and you adhere to the rule and you filed it according to the rule, and they never entertain it. That will violate your due process right, because that's a procedural. It's supposed to be procedurally sound, meaning that all the procedures that's available to you, you have the right to exercise. If the court do not give you that, then they're violating the due process, procedural due process. Now, substantive due process is another animal. It's going to be based upon circumstances. Like, did they give you, like, for example, did the court, like, say the court, like you filed a motion and the court gave them 60 days, the prosecutor 60 days, but then the prosecutor may file something and they only give you, there's not really a timeline on it, they only give you 5 days to answer when they had 60 days. And now they trying to go on with trial, and they didn't allow you to really properly answer the motion. You like, and you might have to work, you might go to school, there might be all types of things that go into play into that, and they didn't give you enough time to respond to deal with that accordingly when they had 60 days. You see what I'm saying? The court allowed that. That's gaining a technical advantage because they had more time to deal with the issue than you did. When you only gave, the court only gave you 5 days. So the court got to be as fair as possible by providing you the same remedies that they gave the state. So that would be a substantive. So substantive is not, it can be an unforeseen issue, something that they never seen before. It really deals with the circumstances, and it helps maintain the integrity and the fairness of the case. Anything that affected the integrity or the fairness of the case is normally going to have something to do with a substantive due process. It can be definitely procedural, but it's going to be something depending to your circumstances, and the circumstances is not going to be really based upon a particular rule. It's going to be something not associated with a rule that affects your ability or affects something to maintain the integrity and the fairness and give the one party an advantage over the other.
Okay. So getting back to the interlocutory appeal. How does that play?
Well, the interlocutory appeal plays in a part where you got to remember, like, if the court does something like that affects a right that that it's a closed issue on, then you can move on for an interlocutory appeal. You just can't file an interlocutory appeal. It has to be an issue that's been resolved and it affect a very important right.
When do people usually file in an interlocutory appeal? When do they? Is that something they file if?
They normally file that. A lot of the times you can file that probably. You can file that pretty much in any phase other than mostly post-trial. You're going to probably file that probably before you go to trial or during trial.
So you're saying that this appeal is different because you can file this at any time before post-trial.
Yeah, I would recommend you do that before post-trial.
Right.
Or
So that's
before
different than a regular appeal.
Right.
Appeal is usually done after trial.
Right.
Post-trial.
Right.
Okay.
Right.
Gotcha.
This appeal is basically done after you hashed out all the issues. Normally, when interlocutory is done, is when they affected probably a procedural, something very procedurally, or they tipped the scale so unfairly that it jeopardized the whole integrity of the case and it's affecting your right. So normally it has to be a very, very important issue to file the interlocutory appeal. So you just got to know when to file it. And I'm going to say 9 times out of 10 it's going to be something that procedurally unsound, something that the court didn't afford you by the rule and making it procedurally unsound. Meaning they're not following the rules they're supposed to follow. The court's supposed to follow the rule. No one is an exception to the rule. Everyone has to follow and adhere to the rules of the court.
Would you file an interlocutory appeal after your motion's been denied?
Yeah, that's when, most of the time, that's when you're going to file it, when it was an issue, a very important issue, because like I said, if you never brought it up, you never argued it, then you don't have a right to argue it on appeal. So it has to be something that you presented to the court and they denied you of the right of doing, and they're supposed to, and it's going to jeopardize your case. So depending on what it is, what is the procedure in which they violated, and how you went about hashing it out with the court is very important. How you presented it, did you follow all the procedures required to get your motion heard? Because sometimes you can file a motion out of time and they won't entertain it, and you are out of time, so you might not have the right to exercise the application at that point in time because you filed it out of time. So, but if you filed it in compliance with the rule, you perform to the letter of the rule, then it's a very important issue.
No doubt. Those are all my questions. Is there anything else you wanted to deal with as far as the appeal?
Appeals are tricky. Just to let people know, appeals, you have to be, I try to tell people, you have to have your legal etiquette together. You have to be articulate. You have to understand this process. You got to be able to connect these dots. So I think a lot of times when I definitely be looking at appeals and how people go about arguing appeals, a lot of them just don't perfect the process. Most appeals, especially by proceeds, they're not, the process not perfected. They're filing habeas, they're filing things they didn't do things correctly, and they didn't argue certain things, and they're trying to even bring new issues in that the court will not entertain, and they didn't safeguard their rights because their attorney either didn't, or they didn't know how to safeguard their rights, and they didn't converse with enough people who was familiar with the process to ensure how to be effective in the court. So I just want people to understand, you have to do your research. This is not a fly-by-night thing. You have to take time, and most people who are experienced, they're experienced for a reason, because this is years of study and research that they have dedicated their life to doing. So this is something that you're not going to just always pick up and run on. There's very few people, a exception of the rule. I mean, a very, very, very small percentage. So I just want to hang my hat on that. So if you got an organization that is performing and they say that they got, check them out, see what they offer. But definitely you can come to Moorish through KEMIT. We're gonna show you what's up. We're gonna give you some love, and we're gonna help people develop their pro se ability So they not only they can be procedurally sound, procedurally correct in dealing with the court, but then we can show them how to develop their court IQ on how to deal with that. That's a whole nother topic, because you still got to, once you get all this stuff right, you still got to learn how to go in there and argue and deal with the court and know when they're doing something wrong or when the judge doing something wrong, so you can call them on the floor on it, so that you don't get yourself in a place where you didn't argue something because the judge overtalked so much and you allowed the judge and the prosecutor to overwhelm you, and you didn't get your case heard like you needed to be. So that's Keng El Bey. Is one up, one love for everybody out there that's listening, checking out. So we on the road, y'all. We doing something. Check us out, 2015, 2016. Big things is happening. Keng El Bey, and I'm out.
Yeah. Check out our website, indigenouservices.webs.com, and you can follow me on Instagram, Moorish Chief Noble. We out.
Peace.
2009.